on the original patent, it does say granted to the grantee in the county of, and he is, you know, on you. He's into the county court.
But what you do is you go get a surveyor to come out. You know what the difference between meets and bounds and property and real estate?
Well, as soon as you call it property and real estate, it's colored. You now have a colored. Anytime it's colored, you know it's colored for tax purposes, right?
Yeah. What they do is they did on the deed of trust. They have a right of way, and the right of way is the township range number, township number, section number, and lot number.
Right.
They lay that over onto the meets and bounds, which is your direction and distance. See, under common law, they measure property, not property, but land. See, they called it land back then. They didn't call it property.
Right.
And land was described, legally described in distance and direction. Like they'd say 260 feet northwest or 390 feet north-south.
Yep.
And then they use landmarks. Like they would say the 290 feet northwest at the tree, they would describe the tree and then or a large rock as landmark. That's how they described land. They weren't describing property, they were describing land. What does a deed of trust say? A deed of trust uses the word property. It doesn't use land. So what you have to do is get a surveyor to come out and do a survey on meets and bounds. Tell him you want meets and bounds. He'll know exactly what all surveyors know this.
Well, I did one on my own. I did a meets and bounds on my own. I don't know if that's valid or not, but I took it from the quarter section corner where they referenced, but I used the satellite dimension, you know, the 45 longitude north by the latitude west, and then I went down from there and basically followed all their dimensions right over to my lot, and I didn't use any township range or anything. But a problem that I have, and I don't have a good answer to, is on the patent. Okay, on the original patent, it does say granted to the grantee in the county of, and he is, basically they said it was in the county, right on the darn land patent.
Okay, but you don't want to use the land patent.
Okay, that's what I was afraid you were going to say. After all that work I went through, but I still have to prove out an abstract, so I still need the land patent for that. But I mean, or at least I assume I do.
No, you don't. You don't need the land patent. Get rid of it, because land patents are based on military districts. They divided the United States up into 12 military districts. That's what your land patents were based on. You're under a military venue. So what you do is you go to a surveyor, get a meets and bounds, and he'll issue you an abstract of title, and then you publish it in a newspaper.
60 days?
You have title and ownership of the land by meets and bounds. And anybody who doesn't come in and lay claim to the property is excluded from claiming title and ownership of the land. Then you file a petition with the land court, which is your probate court. In your state would be the county court. In California, it's the probate court, because they moved the county court. They made the probate court the county court. And you file a petition, and you get a quiet title on your property, that you have title and ownership to it. They can't come in. That's how you make them produce the note. They're claiming that they own the land because of a mortgage, and they don't even have the note. They can't bring the note in there. Well,
yeah, but I don't have in my case, I don't have a mortgage. They still, force you to pay taxes.
Sure you do. If you got a deed of trust, you got a mortgage. Did you know a mortgage? Did you know a deed of trust is a security?
No. Well, I've got a warranty deed. It's not a deed of trust. It's just a warranty deed.
Yeah, what they do is they take that, the deed of trust is a security. They take the ad valorem tax that they collect from the warranty deed or the deed of trust, and they buy mortgage-backed securities with it.
You're kidding.
I can prove it.
And then what? Charge the profits to me?
Yeah, they're charging it to your. They're using your deed of trust to buy mortgage-backed securities.
Small world.
Go to. It's right up on the Texas website. Just type in ad valorem tax. And it tells you how they do it. They go into a great deal. They take the deed of trust and the tax, the ad valorem tax, which is your property tax, and they take the revenue and they buy mortgage-backed securities using the revenue from the deed of trust.
Okay, but how can they do that when there's absolutely nothing whatsoever on the deed that grants them that authority?
Because a deed of trust, if you go get the Securities Handbook of 1933, it says in the securities, I'm talking about the SEC, Securities Exchange Commission. They have a handbook, 1933 handbook. It says when a deed of trust is in the hands of a third party, the managerial hands of a third party, it's a security.
So the only way that we can stop it is basically to get the deed of trust back.
Yeah, you know what? Yeah. You know what happened? One of my students went into court, and the federal district court judge told him, when you go to closing, take the deed of trust. Give him the note and walk out with the deed of trust. Do not give him the deed of trust.
Well, how does a person get the deed of trust back once they've got it in their grubby hands?
Well, you're the donor. You donated it, didn't you? Fire him. Fire the trustee. You know who the trustee is? The register. The county recorder. Fire him. Appoint a new trustee.
And a new government trustee?
Yeah, you got the power of appointment. You donated the property to him, didn't you?
And who would be a good choice to choose for that isn't going to make matters worse?
Well, let me read something to you. See, this is why you have to understand what's going on. Let me read this to you. Then you'll understand what's going on. This has been going on 1066 under the Norman Conquest in 1060 Norman Saxon Conquest.
Oh, we're going to talk about the military rule?
Okay, here's this is insinuation. INSINUATION. Insinuation under the civil law is the transcription of an act on the public registers, like our recording of deeds. It was not necessary in any other alienation but that appropriated to the purpose of donation.
So
alienation is a transfer of right, title, and interest. So what you're doing is transferring right, title, and interest in the property to the register by donation.
We donated our land to them.
Yeah.
Well, then that would make them responsible for this. There's another angle to make them responsible for this tax.
Yeah. Yeah, they really own there was a mortgage on the property before you ever got a loan.
Because, it's originally disposed of, according to the records, by the United States when they, signed it out to the territories. Supposedly, it was disposed, and if you look at the old land records, it says the destruction of the property, of the public lands, like the Northwest Territory and whatnot, supposedly sold into the private, you know, but somehow they got it back, and it sounds to me, from what you're saying, they got it back when we filed our titles into the recording office.
Yeah,